This is the Massachusetts real estate brokerage portion of the 12-hour of continuing education module. A brokerage is something that a broker will open and hire other real estate agents to work under them and manage them in a professional manner. And a brokerage is a service that allows clients to sell and or purchase real estate. In order to do that and collect a fee, someone finds a piece of property or wants to list a piece of property with a real estate professional, and those professionals must be licensed as a salesperson or a broker. All salespersons must be employed by a broker in a brokerage in order to operate and transact property sales in Massachusetts and in the federal government. All real estate fees can only be paid to the real estate brokerage. All commissions and fees are negotiable and are subject to antitrust laws. Antitrust laws fall under what's called the Sherman Antitrust Act, where price fixing, allocation of territories, customer tie-in agreements, boycotting, and those types of things could cost anyone who is convicted of violating those laws up to $1 million and 10 years in prison if you're an individual, and up to $100 million if you're a corporation. So anytime that you're boycotting your services, you're price fixing, you're monopolizing, you're trying to territorialize, and or you're trying to price fix with clients, meaning you could charge 6% and tell them that that's what we all charge. We all charge the same thing. You're not going to get a different price. Those things are called price fixing. Client funds, escrow accounts, trust accounts, and record keeping. In order to own and operate a brokerage, you're required to open what is called an escrow account, also known as a trust account. This is an account that the broker holds other client money on behalf of those clients. It is not the broker's money. It cannot be used by the broker for any reason. It needs to be set up separately as an escrow account, and that escrow account tells the world that that money is not your money in case of a lawsuit or bankruptcy or other situation where someone may try to take your own personal funds. This is an account where banks will not allow any of that money to be dispersed because it is labeled escrow account. So usually in a transaction, the real estate broker or the attorney for the seller will hold those funds until the closing of the transaction. The responsibility of the broker and those client funds are proper accounting and distribution at the termination of the agreement or at the consummation of the agreement. Brokers are required to keep records of the funds in an escrow account and clearly indicate the date received, who they received the money from, who they expect to write the money back to at the closing, and then when they do, the date of the withdrawal, the name of the person that received the withdrawal, and any other pertinent information concerning the withdrawal. A copy of all checks written and all checks received must be made and kept with that file. The broker has no claim to the money. It is not the broker's commission. The account can be interest-bearing or not interest-bearing. If the buyer requires an interest-bearing account, all you need to do is open up a separate escrow account for their transaction. A salesperson does not hold deposits. All monies are to be turned over to the employing broker. Brokers must keep a physical copy of all checks and the accounting of the escrow trust account for 3 years. The contractual agreement should direct the broker to deposit the funds and give instructions as to the withdrawal in case of a default. Escrow records and bank accounts holding client funds are subject to inspection by the real estate board. The broker must deposit the money received and may not bring any undeposited checks to a real estate closing. It's important that all checks are deposited immediately upon the acceptance of any offer or signing of a purchase and sale agreement. Failure to deposit the money can result in treble damages, and treble damages are up to 3 times the amount of the check, including court costs and attorney's fees. So there are different agency relationships in a brokerage, and you have different players. We have clients, and a client is someone who you have a listing agreement with. They've hired you to sell their home. A customer is a buyer who does not have an agreement, and the customer is someone who's working with an agent to find a home. You have a principal, and the principal in any transaction could either be the seller or the buyer. So you'll hear a lot of people being referred to as the principal, and that could be either seller or buyer, or additionally, it could be the principal broker or the broker of record in the office. Broker salesperson is someone who holds their broker's license but does not act as a broker. They act in a capacity of a salesperson and have no brokerage responsibilities. A salesperson is an agent of the broker, and the agent has a fiduciary responsibility to their client and to the broker. Salespersons do not receive checks directly from closing transactions. All of their compensation is received from the broker. Realtors. A realtor is a membership to a private organization, and a realtor is a member of the National Association of Realtors and subscribes to a specific code of ethics. It is a trade organization, and it is not required of any licensed real estate agent to join. In Massachusetts, we have a couple of different terms for agents. We have seller's agent, we have listing agent, buyer's agent, selling agent, sub-agent, disclosed dual agents. So we have a combination of different names and terms for people in the brokerage. The seller's agent is someone who is responsible for the listing and the seller, and they fall under a category called Old Car, which is an acronym for obedience, loyalty, disclosure, confidentiality, accounting of funds, and reasonable care. If you're a seller's agent, you could also be known as a listing agent. A listing agent could be either a seller's agent or a facilitator. Buyer's agent. Buyer's agent has the acronym Old Car as well. Old Car again meaning obedience, loyalty, disclosure, confidentiality, accounting of funds, and reasonable care. They are working with the buyer to find them a home. Selling agent could be a buyer's agent or a facilitator. A selling agent is an agent who actually found the home for a buyer. They actually sold the property. Sub-agent. A sub-agent is someone who works with either a buyer's agent or a seller's agent. They are not responsible to the seller or the buyer. They're just assisting one of those two agents. So let's talk about disclosed dual agency, disclosed dual agents. If you're working with a buyer and a seller in the same transaction, you are required to disclose that you are working with both buyer and seller, and they have to agree. Anything other than that is illegal. In Massachusetts, we have either a disclosed dual agency or a designated agency. Each brokerage will determine what type of agency they will operate their brokerage under. If you're a disclosed dual agency, then you are allowed to represent both buyer and seller by presenting that information to them at the beginning of any transaction or relationship. If you're a designated office or agency, you will do the same by notifying each seller and buyer that you're working with that you are a designated agency or designated office. And what a designated office means that each individual agent in the office is working solely for either a buyer or a seller, specifically in that transaction. And anytime an additional party wants to be involved to become a dual agency, you would have to get the consent of both buyer and seller. And that's more explained in the Massachusetts rules and regulations, so I won't continue on with any more of that conversation at this point. A single agency are agencies that set themselves up to represent buyers only or sellers only in a real estate transaction. In Massachusetts, a facilitator is what's known as a neutral party. They do not have any fiduciary responsibility to either the buyer or the seller, meaning in Massachusetts, they do not have what's called old car, obedience, loyalty, disclosure, confidentiality, and reasonable care, but they do carry what's called A for accounting, and that would be accounting of their funds. So anytime you're working as a facilitator, please let your buyer or your seller know that you're not responsible to keep anything confidential, and anything that they don't want other people to know, they shouldn't be telling you. You have no obligation to keep it confidential. An open house agent is an agent who works solely at open houses for perhaps a larger office. They do nothing else except open houses. You are required to be a licensed real estate agent in order to do open houses. Real estate assistants in an office can be either licensed or unlicensed, but depending on that, depends on what services they can offer the brokerage. Any real estate assistant within a brokerage who is unlicensed cannot do anything a real estate licensed agent can do. Basically, if you're an unlicensed real estate assistant, you can file, you can prepare paperwork, you can deliver contracts, but you could never speak to any buyer or seller about a transaction. You cannot discuss anything about properties to any person, nor can you do open houses, show property, or anything a real estate licensed agent can do. A franchise is a large brokerage. Just like you would buy a McDonald's or a Wendy's, you would buy a Century 21 or a Remax. Franchises have all kinds of licensing fees and royalties that are paid to the parent company. Menu service. A menu service is something like a la carte. We charge a percentage, or we charge a flat fee, or we charge a specific item fee. Maybe you just want me to do your paperwork. Maybe you just want me to list your house. Maybe you just want me to help you market. This is your business. This is your brokerage. You can charge whatever it is that you see fit, obviously within the law. A fiduciary responsibility and relationship is something that both buyer and agent have, and it's a level of trust between both parties. It is required that we are all ethical in all of our transactions with buyers and sellers. Compensation and commission. The broker of the office owns all listings, all buyers, all sellers, transactions. Real estate salespersons working for a broker do not. They are paid a commission to bring those transactions into the brokerage. Therefore, all transactions that are closed, the brokerage or the broker of record in the office is the person who is receiving the check. That broker will then cut individual checks to each salesperson for the job that they've done. All fees are usually set in what you call your MLS listing, and you would know when you're showing a piece of property how much that brokerage is going to pay you if you find a buyer and close the transaction. It is illegal to fix commissions between offices, and that's where we go back to the Sherman Antitrust Act. Anytime you're in a situation where agents, brokers are discussing fees and commissions amongst themselves and they're not working within the same brokerage, that's the time that you want to walk away, because that is illegal. Your office can charge whatever they want. Your office or your broker can charge whatever he or she desires. It's your business, again, within the law. Multiple listing service. A multiple listing service is a clearinghouse for all of the inventory, the sold properties, the for sale properties, properties that are under agreement, anything and everything that's been on the market that has gone through multiple listing service will be there, and they carry that information for about 20 plus years. So you could go even as far back as 20 years to see what a listing looked like back then if you needed to, and sometimes you do. When you put your information into an MLS or a multiple service listing, it funnels out through to all the internet services such as Trulia, Zillow, Redfin, Realtor.com. So you're getting a big bang for your buck when you are part of the multiple listing service. However, it is not a requirement to be a part of the multiple listing service in order to perform your duties as a licensed real estate agent. In a multiple listing sale, the information in the multiple listing will be as accurate as it can possibly be. You should be able to rely on that information in order to disclose any details to your buyer looking at property. That MLS listing as well will tell you how much you're going to get paid if you do sell this property. Sales agent compensation. Sales agents are allowed to receive compensation only from their employing broker. The agreement with the broker and the sales agent is determined between them. It's a mutual agreement between the two of them. There are no right, wrong, or indifference when it comes to your payment in arrangements of commissions. Right now, we're going to talk about sales agent compensation. First and foremost, let me inform everyone that sales agent compensation, there are no laws around it. As a brokerage, they are allowed to offer you whatever type of compensation that you and the brokerage agree on. It can be a salary, a commission split, or any type of an agreement. Most brokerages have a plan already set for new agents coming on, agents with experience, agents that have a clientele with them. And I believe that in most brokerages, unless you're a new agent, your commission split is negotiable or can be negotiable. When you are working with a brokerage and your commission split is 50-50, that means that whatever commission the brokerage is entitled to, they would keep 50% and they would cut a check for you as your commission for the transaction in the amount of the other 50%. An example of a brokerage who has a listing and a buyer in the same office. And if you will recall, a dual agency is required for this transaction to happen. But it does often. Brokers would receive the full commission from the seller at the transaction. If your brokerage receives a check in the amount of $20,000 at closing from the seller, and that brokerage has employed both the listing agent and the selling agent, the listing agent would get 50% of the listing side of the transaction, and the buyer's agent would get 50% of the buyer's side of the transaction, and the broker keeps the other 50% of each transaction side. If you can think about a brokerage getting a $20,000 check, $10,000 of that belongs to the buyer's side, and $10,000 of that belongs to the seller's side, which means with a $20,000 check to the broker, the listing agent would receive a check in the amount of $5,000. The selling agent would receive a check in the amount of $5,000, and the broker would keep $10,000. That would be an in-house transaction as a dual agency. Those can be typical, and that is why a broker might push a little bit more or give a bigger incentive for you to sell that property within the office. A typical example is selling a piece of property and having a different office find a buyer. If your office or your brokerage is the listing office, your brokerage would receive that same check in the amount of $20,000. And if they offered a commission split with a buyer's agent or buyer's agency, they would cut a check for $10,000 to that other brokerage. And that other brokerage would handle their check commissions to their buyer's agent in their office, and your brokerage would give you 50% of that check. And if you break that down, the listing agent in your office would receive $5,000 and your broker would receive $5,000. So if you can understand that, it would be advantageous for your brokerage to have both the listing agent and the selling agent in the same office. The broker gets a bigger cut of the commission. You don't, but the broker does. So that's why they will give you an incentive. Let's talk a little bit about listing agreements in a real estate brokerage. When we talk about contracts within a brokerage, contracts are bilateral agreements. Bilateral agreements are the seller is going to sell their home through your office and pay you a commission. You, in turn, are going to market their property and find a buyer in order to receive that commission. These are known as listing agreements. There are 3 types of listing agreements that a brokerage can offer. The main and most important listing agreement that a brokerage wants you to get working for them is what's called an exclusive right to sell. And this is the greatest type of listing agreement with the greatest protection for the real estate agent office. This agreement allows for the real estate brokerage to find a buyer, market the property, and is entitled to the commission at the time of closing. This is always the type of agreement that a broker's office is trying to obtain. This type of agreement can run anywhere between 3, 6, 12 months, whatever the seller is willing to give you for time to market their property. The second type of agreement is called an exclusive agency listing. An exclusive agency listing is when the seller wants to retain the right to find a buyer. And basically what is happening here is the seller is competing with you, the real estate agent, to find a buyer in the hope that they find the buyer before you do, which means they will not owe you a commission. Those types of agreements are not the kind we like, but sometimes we do have to accept them if we want the listing. So now we're in a race between us and seller finding a buyer. There are different ways to handle the situation where the seller may agree to put a list together of the specific buyers he or she has in mind. You may give him a limited amount of time, 30 days to find a buyer. You can always work it out to the benefit of both parties when necessary. The last type of listing is what's called an open listing. What an open listing is, nothing is in writing. It's a verbal contract between a seller for sale by owner as a unilateral listing. And a unilateral listing is the seller saying, hey, my house is for sale, and if anyone finds a buyer, bring them to me, and I will pay you a commission. That is the least favorite of all. But if you have a buyer who is looking for a property, such as the seller's, then you still can make a deal from it. But what you really want to keep in mind is, if you have a for sale by owner and you have a buyer who is interested in looking at that property, you want to get an agreement, even if it's a limited agreement to a day, a week, a month. But you want to ensure that if you bring the buyer to the property and the buyer decides that they want to purchase the home, you will have in writing a legal agreement to be paid a commission if the buyer continues and closes the deal. How do you want to do that? You want to do that before the buyer steps foot in the house. If you call on an expired listing or a for sale by owner and you do have a buyer, then you want to contact the seller, ask them if they would allow you to show the property to a buyer, and would they sign an agreement before you bring the buyer that will give you a percentage of the sale of the property for facilitating the deal. So always make sure you do that prior to bringing the buyer to the property. That will guarantee you your payment should the buyer proceed with the sale. Now, these are the 3 most common listings in a real estate brokerage. However, it is your company as a brokerage, and you can expand on these listings, create different terms on these listings, because again, you are a business and you have the right to set up your agreements the way you want to do business. Everything here is generic. Some offices have what are called buyer agency agreements, and they pretty much mimic what our listing agreements are. The purpose of these buyer agency agreements are many times real estate agents drive people around, look at homes over and over again, and then all of a sudden a buyer wanders off, finds a piece of property without your involvement, ends up purchasing it, and you've done a lot of work. In order to protect your time and involvement with any buyer, one might suggest a buyer agency agreement. The strongest one is called the exclusive right to represent, and that would guarantee that should the buyer go off and find a property, maybe it's a for sale by owner, maybe they walked into an open house and the other agent won't work with you, maybe they just called another agent. If that happens and you have an exclusive right agreement, then you will be able to collect from the buyer whatever that agreement indicated. The second type of buyer agent agreement is an exclusive agency, and that would allow the buyer to find a for sale by owner on their own without having to pay you a fee. And then, of course, what we do in Massachusetts for the most part are open buyer agreements, and that is where we don't require the buyer to sign an agreement. Hopefully our skills in sales and our skills in customer service will keep the buyer with you throughout a complete transaction, meaning you are able to satisfy the buyer's needs, find them a home, and close the deal. Many listings in a brokerage have what's called a protection period. What that does is it allows the brokerage to be compensated for any buyer who comes in after you have shown that buyer the property, but your listing has expired. If a buyer decides that they want to go back and look at that property a second time while you had the listing with that seller, and that buyer chooses another real estate agent or goes back in as a for sale by owner, this would allow you to collect under what is called procuring cause. This protection period can be anywhere between 30 days, 60 days, 90 days, 120 days. It's negotiable between you and the seller, whatever the seller is comfortable signing with you. It also eliminates the open house, "Oh, you are a friend of mine. I remember you from high school. Hey, my listing expires tomorrow. Why don't you come back next week and we can cut a deal without a sales commission to the broker, which means I can reduce the price." Hopefully, this type of an agreement or protection period within your agreement will eliminate those types of things. And that's what it's meant for. So how does an office terminate a listing agreement, or how does a seller terminate a listing agreement? A listing agreement can be terminated in a variety of ways. One is expiration. When your agreement expires, it is over. If you have a 30-day agreement, 120-day agreement, 6 months agreement, whether you have sold the property or not, your agreement is expired. and that is a form of termination. Death. If the owner of the property dies, they no longer own that property. Someone else will own that property. It will not be the original owner who signed the listing agreement. If the salesperson dies, then the listing is not terminated. It still belongs to the employing broker. Don't let that confuse anyone on any tests that you may take. It is a trick question. Performance. When you have sold the property, completed the sale, you performed all of the duties of the contract, therefore it is over. You can no longer resell that house under the original listing agreement. Agreement or cancellation. Parties can agree to terminate. They can agree to cancel a contract. They can go to court and have it rescinded if necessary. Anytime a seller and a brokerage decides that it's just not working out for either of them, they can mutually decide to rescind that contract, which means basically tearing it up and going back to day one for everyone involved. Abandonment. A listing broker may not be servicing the listing or communicating with the owner. The owner can then notify the broker, if necessary, in writing and terminate the contract due to a lack of service. Destruction. If the property gets destroyed by fire or other means and there was a building on the land, then you no longer have an agreement to list land and building. The contract would be terminated. Title transfer. If the owner loses their title due to any foreclosure, bankruptcy, condemnation is a process under what is called eminent domain. That means that the owner that you sign the agreement with no longer owns that property, therefore the listing agreement is terminated. And lastly, eminent domain is the law that allows the government to come in, purchase your property at a fair market value if and when they need to use it for the public use. Perhaps it's building a new highway, expanding a highway, a road, adding a hospital, expanding a hospital, fire station, etc. Anytime the government needs to take your property for the good of the public, it is known as eminent domain, and eminent domain is the law. The process is called condemnation. So I'll just run over a few of the players in a brokerage and how it all works and is put together. The broker of record of a brokerage is the owner of the brokerage or the broker of record under the law in Massachusetts. They are known as the doctrine of respondent superior. When you have the broker in the office, he is the superior. He or she is the one who lays out all of your policies and procedures in an office. The broker, upon employing any salesperson, is allowing you to act on behalf of the broker and the brokerage. Therefore, you are obtaining responsibility, and the broker retains responsibility for your actions. That is why it's very important for a broker to be able to maintain and manage a number of agents, training them appropriately, because the broker will have the same consequences that you may have should there be some type of an issue. Again, it's known as doctrine of respondent superior. It creates a vicarious liability between the broker and the agent. There is also a vicarious liability between seller, buyer, agent, and broker. Anytime a seller hires you and a buyer works with you, and you have created some type of an issue, misrepresentation, or not disclosing information that you were required to under the law, you have now created a vicarious liability between buyer, seller, agent, and broker. When you take buyers and sellers out, when you list property with them, you are creating what is known as ostensible authority. The broker of the office allowing you, the agent, to discuss matters with buyers, sellers, sign agreements, review contracts, etc. The buyer and the seller have a view of what is known as ostensible authority. The agent has the authority to work on behalf of the principal. And that goes for seller hiring agent to represent their home in a listing agreement. Special agent. In real estate, we are known as special agents. We have a specific license to sell real estate. General agent would be any agent who is working for any person and has generic duties, whether in real estate or not. Universal power of attorney and specific power of attorney. If you have universal power of attorney, an example would be your parents might be in a home and they have no control over their ability to manage their finances, and they have given you the authority to manage anything and everything for them as they would. That is known as universal power of attorney. Specific power of attorney is known as an attorney in fact. It is a specific thing that you would do. If, for instance, your seller is out of town during a closing and they need to sign documents, they could give you specific power of attorney, or they could give it to someone else, and that someone else would sign all of the documents on behalf of the seller. And once that duty is completed, there are no other specific items that they could do. It's once and only once, which is different from the universal power of attorney. In a brokerage, most agents, brokerages, and brokers will obtain errors and omissions insurance. That protects them against any accidental mistake during any transaction. So if you are sued because of an error or an omission, then more often than not, errors and omissions insurance will cover a mistake. However, the insurance does not cover against any fraud or willful misrepresentation. And lastly, under disclosure, caveat emptor means let the buyer beware. Caveat emptor is not allowed in real estate. We do not let the buyer beware in real estate. Any agent that is selling a home in an as-is condition still must disclose all of the defects of the property. The property must have proper representation. No matter what the seller asks you to do, you are required by law to disclose all information about the property, the good, the bad, and the ugly. If you want to protect yourself against a potential lawsuit, or if you are pulled into a lawsuit and you want to be on the winning side of that lawsuit, you really should have what's called a seller's disclosure statement that is prepared by the seller, not you, signed by the seller, and given to you. You do not have to disclose that you have it for public record. Buyers will sometimes ask for a copy of seller's disclosure. It would be up to the seller to decide whether or not they want to disclose that information, but it is a good idea for you to have it just in case. That concludes the brokerage portion of the Massachusetts required 12-hour continuing education modules.